Good afternoon, everyone, and welcome to this webinar on wills and estate planning. My name is Ankie van Rijn, and I'm the CEO and the key individual of MyWealth Investments. MyWealth Investments is a subsidiary of Genesis Business School, and the company is also an authorized financial services provider. September is not only the beginning of a new season and the beginning of spring, but it's also Wills Month, and it's very important to get your will sorted out and get your estate planning done well in advance. I'm joined today by Rupert Fourie from Capital Legacy. Thank you for making time to join us today, Rupert, and I'll hand over to him shortly to introduce himself and to tell you guys a little bit about his background. But I would like to just inform everyone that this is not financial advice and this is an information session only. You are welcome to forward questions to us to the MyWealth information inbox, which is info@mywealthinvestments.co.za, and we will gladly get back to you with answers on all your questions. So without further ado, Rupert, once again, thank you for making time to join us today, and we look forward to ask you all the questions that we need answers on. So please tell us a little bit about your background and the company that you represent, and then we'll dive into the discussion. Thank you.
Thanks, Aniki. It's a pleasure to be present. It's a pleasure to be on this platform. And yeah, a little bit about myself. I've been in the insurance industry for the last 34 years for my sins, I believe. I love distribution. My role with Capital Legacy is a regional manager in distribution. So my role is to ensure that all our independent financial advisors have access to our company's value proposition to them as well as to their clients. We want to ensure that more South Africans have valid wills in place. We started 11 years ago. Our directors, all ex-financial advisors, saw the need for South Africans to have access to free wills and have the ability to ensure that their legacy lives on after they've passed away. We saw at the time that it's people are confused on how to get a will and what should be in a will, and there was a lot of uncertainty. That's the reason why we believe over 75% of South Africans still don't have valid wills in place, and that's a number we chase on a monthly basis to ensure that everybody gets access to a will as easy, as professional as possible, and also in the comfort of where they would like to be seen. That's our value prop. We also look at the estate portion of things, so drafting the will is only one part of our value proposition, but also administrating the estate when somebody passed away. That's our passion. We believe that the loss of a loved one should be an easy process for the loved ones, for the beneficiaries, the people who stayed behind, due to the fact that it's already emotional intense to lose somebody that you've loved. We also would like to have that process as smoothly as possible. Yeah, so that's my background. My company, we've made big changes in the industry, not only from a getting a will in place point of view, but also from a financial advisors and advice point of view. And more about that a little bit later.
Thank you, Rupert. And also, just for the participants, I don't know if they are aware that Capital Legacy is underwritten by Guardrisk. I don't think
that's right, Joe. We do use Guardrisk as our from an insurance point of view. That's where we have tied. They are basically our underwriter for our product, and that to ensure that the cost in your estate is being looked after. So we effectively, with our experience in dealing with estates over the last 11 years, we've seen there's certain costs, and that's not being addressed by normal financial planning. We've created a product, an insurance product, to assist people to make provision for those costs. And I'll unpack that also a little bit later.
Yeah, we'll get into that. Okay. So as you have rightly mentioned, the will is just one aspect of estate planning, but that is the starting point.
And not
Yeah.
only a will, an updated will. Because believe me, I had a look at my will the other day and I actually had it drawn up, I think a year ago, and already I had to make changes again. So it's very important that it needs to be updated as well, not only the fact that you have to have a will in place. So let's start at the beginning and tell the participants then, why do you actually need a will? Why is it important to have a will?
I think it's a very good question because we do get that quite often in the field that people feel that they don't need a will. There's many reasons, but
So
I
wait,
think
hang on a
I'll
second,
start.
Rupert. I can't hear you.
Okay, maybe I'm just a bit too far from the mic
I
here.
don't know if you can hear me, but we can't hear you.
Let me just see what's wrong on my side. I it back to normal. Okay, okay. So yeah, your question is why should one have a will? Okay, and a lot of people do challenge that. Why should I have a will? I have little or no assets, etc. Once again, this is a personal thing, but my reasons and the ones that we promote is basically it's your opportunity to choose your beneficiaries in your estate. It's your opportunity to ensure that the legacy you leave behind, the assets you leave behind, goes to the people that you would want it to go to. The second point is in the will you can nominate your executor. So what's important in that sense is that a state process is very technical, very legal, very complicated. And to leave it into somebody's hands that are capable of doing that, this will ensure that your estate are run professionally, and also it doesn't take too long, because as soon as you leave it to somebody that's not aware of all the integrities that a state can bring to somebody, that they are experienced in that. If they're not, they need to go and do some homework. They need to actually educate themselves on how to do it. And this will prolong the process. Any thing that I normally say, which is quite relevant at the moment, is remember a letter of executorship gets issued by the master of the court. And before an executor is not appointed, there's nothing anybody can do. So an executor needs to actually go out to the masters of the office and apply for that letter of executions. We at Capital Legacy do that on a daily basis because we've got thousands of estates that we manage. We visit the master on a daily basis. If it's somebody that doesn't go there often, they need to go there. They need to stand in queues, and it's going to take them a while to get that letter. Not only because they don't know how to, it's just because 9 out of 10 times they've got another job that they need to do as well. So they're not a full-time executor. My advice is use your will to appoint a professional executor like Capital Legacy to ensure that that process gets followed. More importantly than all of this already is you can nominate guardians. Where there's minor children, if both parents pass away, you need to have a guardian, or you need to nominate a guardian that will look after your children after you while you're not there. The will is a valid document where you can nominate and agree about somebody that will look after your children. My story about this is it's also important when you draft a will. Don't just nominate somebody. You actually need to go and chat to the people that you nominate and say, listen, I'm not here to look after my children, I will entrust you to do that. There will be obviously funds available for that. Please, will you be able to do that? Because this is a wish in your will, so it's not enforceable by law, because you can't force anybody to look after anybody's children. But when you have that discussion, it's very, very important so that the nominated beneficial or nominated guardians do agree to that. So that's another part.
Yeah, I think that's
absolutely, because
that's very important what you say there, because you need to communicate with the people, and this is a topic that a lot of people avoid because it's not nice to discuss this, but it's so important for the loved ones that stay behind. So
absolutely, and it creates if it's not nominated, it creates confusion, and it creates some a disruption, because who is going to do this? If nobody can, remember, the court will appoint somebody. The court or the master will appoint an executor, and the executor will then take control over that and decide where the children must go. So this is something you can do in your lifetime, and put in place.
Something there. Rupert, you say the court can appoint an executor. So when will this happen? So say I'm going to use myself as an example. Say I pass on without having the will in place, and I have minors that need to inherit money, and I did not appoint an executor. Can my other family, say my spouse or my parents, appoint an executor after my death, or will it be done by the master without us having a say in it?
Once again, this is if agreement is reached, then the master will honor the agreement between the beneficiaries. Our experience is that beneficiaries don't normally agree about things, because they think one or other party wants to inherit more than they can. So if there's no agreement between the beneficiaries, then the master will take control and appoint somebody. In normal cases, we do find that beneficiaries do agree about these type of things, but also in many cases they don't. So my as I say, it can happen that the more
Especially family members tend to disagree, and one would think under these circumstances they wouldn't. But I think it gets even worse under these circumstances, these difficult circumstances.
Absolutely.
And everybody's under pressure because they need funds to look after these minors. But okay, we're going to get back to that. We're going to move on to that. So basically, I think what's also important to note is that this is also where your estate planning starts. When you draw up your will and you start discussing your numbers and your assets and your family dynamics with a financial planner, and if you are a high net worth individual, you also start planning for estate duty, because this can be quite expensive and you need to you need to plan for this. So just tell us quickly the exemptions and the rates for estate duty that are payable if you are a high net worth individual.
Aniki, before we get to that, I think that's a discussion a little bit later, because there are still advantages I need to address in regards to having a will, because you talk about children and I talk about children, but it's very important for you to protect your children's inheritance, and you can do this via your will by creating trust, because if as you know, minor children cannot inherit cash. So if there is assets that need to go to them, that will go to the guardian fund, to the government guardian fund, if you do not plan for it according to your will or your drafted will. This is particularly applicable where you pass away without a will. And in those scenarios, you could have had a great financial plan to ensure that your children inherits enough capital for them, and you leave your legacy behind in that regards. But if it goes to the guardian fund, those funds get available to the children at age 18. And I don't know about you, but when I turned 18, if I had to inherit a lump sum of money, would I have spent it wisely? I don't know. I don't think so. I mean, I might have bought the GTI that I would have wanted at the time, and not utilize it for what my parents would have allowed me to utilize it for. So by drafting a will, you've got the opportunity to create a testamentary trust for your minor children that will allow them to have access to capital during the period if you're not there, but it will also protect that lump sum for them to a certain specified age that you've decided. Well, not that I'm giving advice, but the norm out there is at age 25. We believe that children are more mature and will be able to spend the money wisely. And this leads into also, I mean, any good financial plan, I believe, and also Capital Legacy believes, starts with a well-drafted will. I would like to challenge anybody that does financial planning, if they do not have access to a will the client's will or haven't drafted it or been in the process of drafting it, it's very difficult to do a proper financial planning if you do not see what the wishes are in the will and stipulated in the will for that matter. So yeah, from an advantage of having a will point of view, it's definitely the right thing to do. You've touched on you know, is a will reviewable? Should you review a will? By all means, a will is a living document that needs to be looked after on an annual basis. There are certain will events that will trigger you to either change or update your will. You know, having children, maybe they're not mentioned in your previous will, you need to update them, guys. And I mean, something like getting divorced, I mean, that's a very important will event as well, because after you're divorced, I mean, your current will be non-valid for 3 months. After that, it becomes valid again. So if you don't update your will during that period, it might happen that your ex will get everything as stipulated in your original will. Other things that you also need to take in mind when drafting a will, you need to remember that you need to also have access to the original will. Only an original correctly signed will is valid. So a copy of a will.
What you mean original is that the one with the wet ink signature?
Absolutely. That is the only original document that the master will accept for issuing a letter of executorship. So safekeeping of your will, a very important part of drafting a will, and also having access to amendments.
You guys also keep
Absolutely.
a copy of the original will for the clients?
We do. Absolutely. We draft the will for the client. We will, any amendments on that will in the future, and also the safekeeping, we make it as easy for the client to say this is free of charge. We do not charge anybody for those services we render. If you obviously use your financial advisor to refer you to us, and we will actually come out to your house with at a time it's suitable for you and your spouse to come and draft that will, or the wills for you. We also calculate the cost in that exercise for you, so that you know and understand, you know, what will happen if you pass away.
Yeah, and then just something else. So you mentioned now that how important it is to ensure that your wishes are carried out and that your children's inheritance is protected. So there are vehicles that we can have a look at just now in a little bit more detail. But also, if you are not married but you live with a partner, I think if you do not have a will in place, that person also might end up not inheriting any of your inheritance.
Once again, you know, so if you don't have a will, remember, then there's certain laws. There's laws that will govern what happens to your assets. So I mean, that is a legal process that's followed, and you're effectively, that might be not what you want to happen, especially in your example. That partner of yours will not be or will be looked after from that point of view. So very important to have a will, up-to-date will in place to ensure that if your living partner needs to inherit from you, it needs to be stipulated in the will, and it will be honored.
Exactly, yes. And like you have also rightly mentioned, you know, the dynamics keep changing. The kids get older. We get so busy, and the kids grow up. And before you know it, your little ones are 18, and then they end up inheriting a couple of million, which they probably will go and spend on expensive cars if you don't train
most definitely
properly. So, right.
Yeah.
So then just to get back to where estate planning, the exemptions and the rights applicable.
Yeah, listen, Aniki, I do believe that everybody's will, or your estate and the values of that is really personal. So there are definitely, and that's the value of getting financial advice and proper financial advice for them to calculate, you know, exactly what is applicable in your estate and make provision for certain things. At Capital Legacy, we make provision for legal costs in the estate, which includes executors' fees, testamentary trust fees, where applicable, as well as property or the transfer of property, the attorney fees applicable in that instance. Things that we don't look at is your taxes, you know. So that is a complicated exercise where financial advisors are crucial to advise and assist you on that, to ensure that you make provision from a life cover point of view to pay those costs at death. So absolutely, my advice to everybody out there is make sure that you tie up with a professional and let them do a proper financial analysis for your personal circumstances and advise you on the best vehicles to follow to address those needs.
Yes, and actually, this is also another important point. You mentioned now the costs that can be involved, like the executive fees. We all know it's between 3 and 5% of the value of your estate.
Yes.
You know, when you go and create trusts, whether it's a testamentary trust or a living trust, there's costs involved with these vehicles to set them up and the running costs. Then also in the case of property, where property gets inherited, transfer duties, transfer duty. You're not going to get around transfer duty. And I think a lot of people avoid this subject and they avoid getting their will in place because they feel 3% to 5% of my estate value, to pay that to an executor, that's just way too much money to give away. But people don't realize that companies like Capital Legacy and many other out there provide such affordable plans to help you cover those fees. So those fees will not be paid out of your pocket or even come from your estate. So maybe you can just shed some light on these products that you have that help people to overcome these costs.
Absolutely, Aniki, and I think I need to take a step back and yes, we know about these fees, and we know, well, or we might not. By consulting or having a consultant, one of our consultants see you, we will explain those costs and we will show you that in your current estate. We will calculate that for you so that you know. Now there are many ways of making provision for these costs in a financial plan, and a lot of financial advisors out there are doing a fantastic job in doing that. But there are, even though there are still costs that are neglected, and I always use the example from a estate process is, remember, you sit with beneficiaries, their expectation is they're going to inherit money. And if there's no liquidity in the estate, that means two things. Either all the beneficiaries need to pay the estate for those costs that hasn't been provided for, or the executor needs to sell assets to make provision for these costs. So the first thing that we don't want is to have people sell assets out of an estate. As everybody must have seen, you know, these boards against the light poles that says estate, you know, auction from an estate or a late estate. People don't go to those auctions to pay market value prices. I promise you that. They want to buy those things for the little amount as possible. So that's the last thing we want to do. We want to make sure that there's liquidity. Now, by doing proper financial planning up front, you can address certain costs in the estate. Capital Legacy makes it our job to make sure that the legal costs in the estate is being addressed and being looked after. So the things that I'm referring to here in our discussion for today is, first of all, you mentioned the executor's fees. Now, executor is allowed to charge the estate certain fees. It's a percentage of the size of the estate or the amount in the estate. That is his pay for doing his work. That's normal. That's allowed. It's not illegal. That's what they're allowed to do. It can be absorbent. The bigger the estate, obviously, 4% of a 50 million rand estate becomes a big amount for doing admin processes. Other cost in the estate includes is if there are property that needs to be transferred from one party or from the person who passed away to the spouse or whoever he wants to leave the property. There are certain admin costs that the attorneys will charge to transfer that. So it's not a transfer duty, but it's an admin fee that's charged by the by the attorneys responsible for doing that. And then another, last but not the least, and it could be the most, is trustee fees. So if I am leaving capital to my children, that goes into a testamentary trust, as I explained earlier, because you don't want it to go to the guardian fund. You want to make cash available for them to supplement their, well, to make sure that they continue living on the standard that they used to, and hopefully there's a capital amount at the end of the trust. To draft these trusts or to set these trusts up, there's a fee. That's a percentage, 1.5% of the initial trust capital. And then there's an ongoing fee. Every year, the trustees are allowed, once again, they're allowed to do that. They do a job for that. So that's 1% of the capital amount of the trust. That becomes their fees. Now, these fees will erode your capital over a term. If it's if your children are still young and it's a 10, 15-year term, these costs adds up, and it actually erodes the capital that you would have loved to leave to your loved ones. Our product makes provision for that. We make sure that these fees are addressed. We indemnify these fees via our product, so those fees won't be applicable in your estate. So you can plan now already to ensure that what you want to leave behind is the value that your beneficiaries and your loved ones get. So that's quite important. Other things that people also need to take into consideration, and yes, guys, these aren't big amounts, but they all add up, Aniki. They all add up. So there are master fees that need to be paid. When properties get transferred, there's clearance certificates that you need to get from the municipality. Very similar bond cancellation fees, if that's applicable. So very similar to when you buy a new property, those type of costs are also there, and they all add up in the estate process. But our product make provision for that. We also make provision for immediate cash. So when the breadwinner in a household pass away, there could be, remember, the accounts get frozen, and there could be a cash flow problem for a period of time before the life cover is paid out, and etc. Because that could take up to 3-4 months before those income gets back into the family or into the household. So we make provision on our plans for a lump sum to be paid out within 48 hours after we've received all the claim documents. And that will assist the loved ones to continue living up until further the rest of the financial plan kicks into place. But that just makes the process so much easier. The biggest challenge, as I mentioned earlier, and I have to restate this, because with the estates that we've been wounding up over the last 9, 10 years, 11 years, it's liquidity is your executor's biggest pitfall. If they don't have cash, remember, the executor don't have access to cash. They're doing a job. If that liquidity is not in the estate, the whole process gets basically stopped until there's cash. So that delays the estate process. And that is why we want to make sure that when we, the executor, we do not have to wait for money to get into the estate. Our product provides that, and the executor's hands are free to do their job timeously to ensure that the process is easy for the loved ones.
So can I ask you then, for a normal run-of-the-mill estate, the will is in place, the original copy is with you guys, the family has an original copy, and by the way, I remind everyone to ensure you know where to find the wills, because that's also very important. So if all of this is in place and there's no complications, what's the average time that it takes for that estate to be wound up versus somebody who passes on without a will, or with these complications and headwinds?
Aniki, how long is a piece of string? Let me answer this, because we do get these questions often, and I want to tell you, and you need to take the following into consideration, because unfortunately, from an executive's point of view, you are in the hands of service providers, and the master is the first service provider. So for us to get a letter of executorship, a letter from the master, can take anything between a week and 3 months. depending on the master you're dealing with, if you're dealing with Johannesburg and Pretoria, you're in good hands. Mafeking, you might be 6 months before you get that. Nelspruit went through a patch where it was difficult. Bloemfontein is good. Cape Town is fine. But what we've experienced is that, especially with load shedding and lack of water, etc., the master's capability of servicing us is totally in those hands. But I'm going to answer your question, but just taking in consideration that we do have product providers. Interesting story, in a estate process, we need the master effectively in 4 instances to get get the letter of executorships, to sign off the L&D account, to approve it and then sign it off, and then also lastly to issue a filing slip for the estate. Now, if the master is 3 months behind, remember that's 4 instances, that's 3 months that we wait for each of those things. So take that into consideration. It's definitely getting better. The master is really coming to the party. This started during COVID, where we really had backlogs, and they are working out of that. So in general, we look at 9 to 12 months. A simple estate where everything is in place. It used to be 6 to 9 months. This has moved on to 9 to 12 months, depending on service delivery from our product providers. Remember, we're also in the hands of the banks out there. So if we need to close accounts and get final balances, etc., we apply at the bank or the specific bank. That bank will check if we are the allocated executor for the estate via the master. So there's once again a delay because of fraud instances where people fraudulently said they are executors and they got cash from banks due to that. So they need to be verifying that if the executor are the appointed one. So there's a little bit delays in those processes as well. But yeah, in a simple, where there's liquidity and everything is fairly above board, no tax problems, because people's tax need to be up to date, or the person that passed away, we need to clear it at SARS as well. So those
the loved ones need to keep funds to pay the taxes.
Absolutely, if applicable. Yeah, so all of those, at the moment, 9 to 12 months, depending if we do. I'm comfortable in if I need to manage expectations, I'm more the 12 to 16 month guy, but absolutely at the moment we are getting estates through 9 to 12 months.
A professional company that specializes in this, 9 to 12 months, how long will it take me if I do not appoint a professional and I don't have anything in place? It'll probably take 3 times longer.
Absolutely. That's my point that I made earlier. We've got what we call runners. I mean, they go to the master every day. They follow up on all the LOEs outstanding or L&D accounts that hasn't been approved yet. So we've got a network that we're dealing with to assist. Obviously, if it's you have to go there personally. That's going to take time out of your day. You'll have to plan so that's where we basically say, our advice to people, if they want to nominate a friend or a family member as an executor, we rather say make them a co-executor with us, so that they're involved in the process, but the doing is still our doing. So we try to advise people accordingly. If they feel that somebody needs to be part of it, we do allow that definitely to have a co-executor. But from being an executor where you're not a professional executor, it's a very, very technical and legal process to follow.
It's not easy to just jump on and become a co-executor or executive. You've never done that before. Something else that you've also touched on earlier that I would just like to bring up again and put it in a bit of perspective for the people who are listening to this discussion. So if you belong to an occupational fund, which is provident fund or retirement fund, you make a contribution which is split between risk benefits that represent your life cover portion, and then you also have the investment portion that goes towards your retirement fund investment. So should something happen to you, or should you pass away, that life cover benefit, if the insurance company is satisfied and feel comfortable, that benefit gets paid across into your provident fund. Then the Pension Fund Act will kick in. And once the trustees, and only once the trustees of that pension fund are all happy and satisfied that payment can be made to your beneficiaries, or they will go and investigate to see who your actual dependents are, and they will go and check in the case of males that they do not have children running around that the wives aren't aware of, because those children have a claim against the estate. These are things
Yes.
that I didn't know. I found this out recently when I started doing a bit of research on this subject. So
Yeah.
people, I think, are also under the misconception that provident funds and pension funds pay out quickly after death. They don't. They don't, because there's a lot of investigation that takes place. The Pension Fund Act is applicable. People do not realize that. I think it takes a minimum of 3 months, if you're lucky, for that
If you
money to get paid out. So that is why it's crucial that you plan ahead. Make sure
absolutely.
that you plan, like you have mentioned, that costs can be covered and that there's money to pay the bills, because the bills don't get frozen with the bank account.
Unfortunately not. Unfortunately not. I think I want to add to what you're saying. A very interesting, what people need to understand, that those trustees of the pension funds, they are held responsible in their personal capacity. So if they make an incorrect payment to the incorrect beneficiary for whatever reason, that they didn't do their homework well enough, in their personal capacity, they are liable for the funds that they've paid out. So that is the reason why they will make 110% sure that they are paying the correct people. What people also need to understand, that is not part of your estate process. Your pension fund money doesn't form part of your estate process. That's excluded, which is good. But what we also, where we've been involved in creating testamentary trusts for minor children, we've actually worked together with these trustees that should the children be inheriting, we actually request them to pay that money into the trust so that we can manage the fund according to that. Some of them do allow us to do that. Others create their own trust for their own product rules or their own fund rules. So once again, coming back to our original point, is when you do sit with your financial advisor, these are very valid questions and valid points that need to be addressed in your financial plan. So you need to make sure that you do allow or make provision for a period where before the estate pays out, so that there's liquidity in the household to look at certain expenses. In our product, we actually do have a benefit that you can take out. We call it estate overheads protector. Now, what this product does, or this benefit in our product does, is it allows you choose what amount. We do a calculation for you, the amount that will be payable to the executor to make provision for certain costs that's continued for a 6-month period. So those would be things like medical aid. I mean, medical aid continues. You need to have medical aid cover for you and your children, for your loved ones. So if the life or the person who belongs to the medical aid passes away, those benefits continue, but it needs to be paid. So you can make provision via our estate overheads protected to make sure things like short-term insurance. You drive your car, your car's driven every day. That money used to be paid by the deceased. So you need to have capital available or funds available to make sure. School fees. The best one that is probably the Wi-Fi cost. I mean, children today at school, they use a lot of Wi-Fi time at home to utilize to do their homework and get. I mean, a lot of schools these days only have iPads. They everything works off Wi-Fi. So if you don't make provision for that, it's not going to be there. So these are planning methods that you can use to ensure that continuation continue. And I mean, whatever benefit is not used. So if you do have a benefit that's paid to the executor that's not used, gets paid out in the estate at the end in any case. So it's not like what you don't use, you don't get. What you don't use will be distributed as per will. So it's a very nice benefit to make provision for that period before the life covers and the other capital amounts paid.
Definitely. I've put that in place, and I must say I feel very happy that I've done that, because it really is very affordable as well. Then
Absolutely.
we're getting towards the last part of this discussion now, but I just quickly want to ask you about people who also own foreign assets, foreign companies, foreign property. I think that is different to people just having investment in shares where funds can be repatriated through the executor. There's a few pointers that I think we should just put out there to high net worth individuals with foreign interests in different countries.
Absolutely. Yeah. So once again, it can be very technical. It can be very planning intensive. A couple of things that you need to keep in mind is where the assets and what the assets are, where they are. I mean, are they in the UK? Are they in Italy? We offer what we call a worldwide will, and what that means is that we even if you do have assets abroad, depending in which country, if it's a if it's a Commonwealth country, they accept our executorship and our masters. So we can actually run that estate from South Africa in a worldwide will. We'll make provision for that. We use Lester Aldrich as the attorney firm that will help us in the process. So it's not necessarily that you need an offshore will for that, a will in the country. You can manage that from your estate within South Africa. Once again, very technical, depending on what type of assets we are referring to. If it's a non-Commonwealth country like Italy, for instance, they've got what they call forced heirship. So there's no executors in Italy. There's an administrator. That's all. It's not an executor because effectively your will is already written by government laws. So people will inherit in your family, your sons and your daughters, etc. There's a specific rules around that. So in those instances, you need to have a document on that side, because they won't accept our authority in that matter. So yes, it depends where you are and what type of assets you have, but we do provide for that. Once again, I do urge financial advice in these instances and get advice around that and have your will drafted properly, because that will also allow your financial planner to plan according to your wishes in your will.
Okay.
Does that answer, Aniki?
Yes, 100%. Thank you very much. And then just lastly, I would like to ask you, these days, most people are involved with so many different social platforms, and we all have different bank accounts with different banks. Some of us have company accounts with more passwords and usernames. What is your advice to people to keep something in the file where they keep the original will with all these passwords so that their loved ones know where to get access to which funds, which platforms to close down, or do people just leave it?
Yeah. Aniki, very good question. And I think, there's Bitcoin and there's a whole lot of different vehicles that people can invest from the comfort of their home on an email basis and internet basis, which is obviously from a one point risky, because who knows about these things? Where are all your shares, etc. I think this is once again something you need to, I call it a life file. So you need to have a life file. In your life file, every single financial and asset, from a financial and asset point of view, you need to have in that file. Keep it in a safe place and make sure your loved ones know exactly where to find it, and update that on a regular basis. And this is also where a financial advisor plays a good role, because they can assist you with what important information needs to be in that file. We are working on something that we are looking at electronic type of a vault where you can place such documents. We're not there yet, but this is definitely something on our radar from a capital legacy point of view, to where you can update these type of information, on a regular basis, ensure that somebody have access to that in the event that you pass away. And once again, that will just make the process, when an executive deals with your estate so much easier. And there are certain things like Facebook. Do you want your Facebook profile to be there forever and a day? Do you want to, have somebody access it and stop it? Those are things that's not necessarily part of your estate process. It's not part of your executor that needs to do that. So communication very important, and having access to the information by somebody that are left behind that you trust. That's where a life file comes in handy, and everybody should have one. I really suggest that, or advise that very strongly, and have somebody that have access to that. But there's a lot of trust in that. Obviously, you can't just leave it to anybody, but that will just make the process at the end so much easier. Currently, we don't have it in place, but we are working towards that to make that part of your will process, to ensure that even that information is kept safely.
I think that's very important. I can't help to sit here and think, if you get that electronic vault in place and that gets hacked, oh my word,
That's probably why we don't have it in place yet. Yeah, no, absolutely.
Ensure you there. That
Exactly.
so important, because once you decide to get that life file in place, if you haven't done it yet, believe me, it takes quite a while to put that together. I keep mine updated, and even just to keep it updated is quite an exercise. So it's very important. Imagine if you take so long to get it in place, the people who have to figure out what's going on in that file, how long it's going to take them. So you got to make it as easy as possible for them and as smooth as possible.
I think it's a South African thing. We love delaying things. I mean, I remember when our your driver's license changed to the card system. Remember, many years ago, and it was all over the news. There were queues in every town around the block for people waiting to get their new cards or go to have their new cards issued. And that's a South African thing. We delay it to the last. This is something you cannot delay.
Because South
We're
Africans
always busy.
are busy. They don't have time to look after their personal lives and their personal. You are right. It's 100%.
And this is something you have to do while you're alive, Aniki. I mean, this is not something, because if that day happens, you can't do it tomorrow because you're not here. But I think what you need to put in mind is to think about, what are you leaving behind for your loved ones? Do you want to leave something that is a mess, or do you want to leave them a process that can be managed professionally? So
it takes stress off them during a difficult time. It will make their life so much easier. So I think I can't believe we have discussed wills here for nearly 50 minutes. I didn't think that was possible, but thank you so much. So from my side, if I can conclude with this message, that a well drawn up will create order and certainty for your family and for your loved ones. And it is something that you cannot live without. You should have a well drafted will in your house, and your close family should know where to find it. Your original wet signature should be on that will, plus the witnesses also have to sign that will. You also need the witness signatures on that will. So please, everybody who is listening to this discussion, get that sorted out. That's all from my side. I'm going to ask you to also give us your closing message, but I also just want to tell our participants that the next webinar by MyWealth Investments will be on the 2nd of October, where we will break down the medium-term budget policy statement with the Head of Economics at Investec Bank, Annabelle Bishop. Thank you. And then, Rupert, just your closing message. Thank you.
Yeah, I need to link into you. I think, seriously, take control of your wealth. Everyone that listens, take control of that and start with having that will drafted. Go and get advice from a professional advisor to ensure that whatever you have drafted in your will can be executed in your estate. Make sure there's provision for your loved ones, and leave a legacy behind. That's Capital Legacy is there to assist you in that process. Ensure that your not only your legal advisor, but your financial advisor, use Capital Legacy to make sure that you are looked after the way that I think you deserve to be looked after. Thank you for the time. Thank you for the platform. I really enjoyed it, Aniki. It's fun. And yeah, can you believe it? 50 minutes later and we're still talking.
Thank you so much. We appreciate you making time for us to join this discussion. I hope we could add some value. So thanks, everyone. Enjoy the rest of the day.
Bye-bye.
Bye.